Now in session.
Okay. The parties, are you prepared for your argument? All the parties are prepared. We're going to proceed as if we were in court. The appellant will go first, and the appellant, Mr. Johansson, you're representing the appellant. Is that correct?
Yes, Your Honor.
Okay. Have you already reserved your rebuttal time?
Yes, I did, Your Honor.
Okay, then the other parties are ready. Okay. Now, while we're proceeding here, if anything comes up, technical problems, please let us know immediately so they can be addressed, okay? Mr. Clerk, will you call the case, please?
Hampton Reserve Homeowners Association, Inc. versus Kirk, Leipzig.
Okay, we'll hear from the appellant.
Good afternoon, Your Honors. May it please the court. Your Honor, with your permission, may I sit during oral argument?
You what now? Oh, yeah.
May I sit?
Yeah, we're all going to be seated, so that'll be all right.
Okay. All right, thank you. Your Honors, about 7 years ago, on February 18, 2014, the HOA filed its appeal in the General Sessions judgment. With the court's indulgence, I would like to briefly address a matter that was not yet addressed by any appellee in their responsive briefs, and except perhaps in passing, but it goes to the issue of justiciability. And Anarian respectfully supports the efficacy of Anarian's standing in this case. Your Honor, on February 13, 2014, in February 2013, Anarian found out that the property that it had a lease purchase option on, was compromised by a lawsuit that had been filed against a gentleman's trust. The name of the trust is a Leipzig trust. It's a Tennessee trust. Very soon after that, I contacted the HOA's attorney at the time who was handling the case. And we discussed a possibility of settling it. It settled very quickly. Anarian stepped in to pay the amounts that had not been paid by the trust for HOA dues. And in return, the HOA was to immediately dismiss the case as soon as the last payment was made, which was in September 2013, and also remove the liens that were on the property that were placed there by the HOA. Now, for purposes, one of the issues, one moment. In September 2013, Anarian made an appearance and then later filed a motion to intervene into the case. Litigants in General Sessions Court may plead their cases orally without filing written pleadings conforming to complex common law rules, which is what Anarian did, and which also the judge in the case, Judge Williams, who has since passed away, encouraged Anarian to brief the issue. The judge also encouraged the HOA to brief the issue as to why an intervention was not allowed. Judge Williams and the General Sessions Court were inclined to allow intervention. The motion to intervene was filed. It was fully briefed. The HOA chose not to brief the issue on a timely matter, and the General Sessions Court entered a judgment, dismissed the case, and also found that there was a settlement between Anarian and the HOA. Now, at that juncture, the HOA had a couple things it could have done. It could have directly appealed to the circuit court for a trial de novo, or there's a modified version, I think it's Rule 60 at TCA, Tennessee Code Annotated, 16-15-727, which allows relief from the General Sessions Court judgment. The HOA has 10 days to do that. The HOA did not, so it waived that issue. So at the time the HOA filed its appeal on February 18, 2014, the judgment had already been entered. The judgment was in favor of Anarian and Mr. Leipzig and against the HOA. Now, the parties to the case in the judgment, as evidenced by the judgment and participating in the General Sessions case, were Anarian, the HOA, and the Leipzig Trust wasn't sued because they sued the wrong party. Mr. Leipzig didn't appear because he didn't have the funds to carry on a defense, and he also knew that the party that was sued in the case was not the owner of the property, the Leipzig Trust, but Mr. Leipzig individually. So Mr. Leipzig,
Mr. Johnson, who was you representing?
I was representing the Anarian Investments, the appellant.
Okay, that's the only party you were representing in this case.
At the beginning of the case, or not at the beginning, I'm sorry, it was filed in April of 2012. In January of 2013, I appeared in the case and notified the court of the dismissal, notified the court of the settlement agreement, and also made a motion to withdraw at that time. The case had basically been over, except what happened soon after that when another attorney came in and basically reactivated the case and started prosecuting it with vigor, which precipitated the motion to intervene by Anarian, which I believe there were two motions, one in, I believe it was November 2013. The second one was in December 2013, and then briefed until the following month in January 15. Now, when the HOA filed its appeal under TCA 1615-729, no civil case originating in a general sessions court, and I'm quoting, Your Honor, and carried to a higher court shall be dismissed by such court for any informality whatsoever. This is something that was mentioned by Judge Williams in the General Sessions Court when he encouraged the briefing on the intervention and was inclined to do that. Now, what happened next was so in civil cases, I'm reading from the statute again, that the higher court shall allow the amendments in the form of action, the parties in the case, and the statement of the cause. Now, under TCA 27-5-108A2, again, these are all in the brief, Your Honor. Pardon me for parroting them back during an oral argument. But if one or more of the parties before the General Sessions Court, again, I'm reading from the statute, Your Honor, General Sessions Court perfects an appeal of a decision of the General Sessions Court to the Circuit Court upon the filing of a notice by any party, a notice of appeal by any party, issues may be brought up for review by any party. Now, that's what the statute says. The statute's clear and unambiguous. It needs no interpretation. The parties to the case were Anarian, Mr. Leipzig, and the HOA. The HOA filed its appeal, and the legislative intent is consistent with the statute, where it states, if one or more parties before the General Sessions Court in civil action perfects an appeal, upon the filing of a notice of appeal by any party, issues may be brought up for review by any party, if legislative intent was necessary, which it is not. The form of the notice of appeal signed by the HOA also states that parrots back 27-5-108 TCA allows you to appeal the judgment of the General Sessions Court. So everybody was in accord when it was appealed. There were three parties. Now, Anarians in judgment includes three parties, not two. But one thing that the HOA forgot to do, they forgot to sue the right party. They sued the wrong party. Mr. Leipzig was not it. His trust was, but he was not it. Now, several dismissal orders were issued by the Circuit Court. The first one was in February 2014. The second one was March 2014. And the third one was several years later in January 2019. Now, the dismissals were all granted. The orders were served on all parties, and there was a Rule 60 motion filed by the HOA based on mistake, inadvertence, excusable neglect, and the dismissals were set aside. Now, one thing that was interesting about what they did in 2019, January 2019, January 2 to be precise, the third dismissal happened, and there was no response to that. Circuit Court served everybody, no response from the HOA. On the very last day to do that, I believe it was December 30, 2019, a motion was filed to set aside the dismissal. Unfortunately, as the HOA's attorney knows, not the current one, but the one at the time, I spent several weeks with my family on vacation. I didn't get to even see the motion until it was up for a calendar. So the HOA sued the wrong defendant in the wrong court for the wrong reasons. Now, this goes to the reasons for the appeal by the HOA. The HOA filed the appeal for a number of reasons, primarily for delay. Number one, by filing the appeal to the circuit court, the Anarian could not enforce the judgment. It was stayed on appeal. By filing the appeal to the circuit court, Anarian did not have a final judgment for res judicata effect in order to enforce the judgment.
Before your time run out. Okay.
Yes, Your Honor.
What does the effect of the March 18, 2020 agreed order of dismissal have on this case?
The March 2020 agreed order has the dismissal of taking away Anarian its day in court, party to the case. And what happened in January, the previous January, when the court dismissed or found that Anarian was not a party, it basically terminated the action as to Anarian. So Anarian was never able to have its trial de novo, have a judgment on the merits for res judicata effect, which is important to Anarian in enforcing the judgment. And that's pretty much it. I mean, Anarian's an aggrieved party. It couldn't conduct any discovery, couldn't do anything. Now, one issue on that.
On this particular case now, does this court have jurisdiction on this case? Is this an issue that has been properly presented to this court?
Absolutely, Your Honor. The court not only has jurisdiction, and Anarian has standing, and it's not moot. That's correct, Your Honor. When
Anarian filed to intervene, did you file as a complainant or as a defendant?
Filed as an intervener, Your Honor, which the court allowed, and in which a General Sessions Court was not disallowed to do under the statute. Again, it's an informal proceeding. Those informalities are not looked the other way when the circuit court takes a look at the case. So, Your Honor, in summation, I'm going to go over some other things later, Your Honor, but the request is that the circuit court judgment be vacated, the circuit court appeal be dismissed, and to affirm the General Sessions judgment, which this court is allowed to do.
Let me ask you, what was the nature of the judgment that you purportedly received in General Sessions? What was this judgment you keep talking about?
Yes, Your Honor. That was on February 10, 2014. The General Sessions Court entered a judgment dismissing the HOA's case because one of the reasons was they sued the wrong party. They also, a judgment was for Anarian and Mr. Leipzig on the settlement agreement because the case had settled, and the court entered judgment accordingly. That was February 10, 2014. February 18, 2014 is when the HOA appealed to the circuit court. So
Anarian received the judgment for what amount?
It was the Anarian received a judgment that there was a settlement agreement which warranted dismissal of the case. In other words, the case that was being prosecuted was already settled 1 year before, which was the March 2013 settlement. So there was the HOA should have dismissed earlier in September 2013. They did not. Another attorney came in and basically, Your Honor, just kind of pumped the case up and prosecuted it when it was against the wrong party and the case had already settled. That's what was the finding of the Judge Williams in the General Sessions Court, and that was a judgment that was appealed to the circuit court and stayed because of the appeal. Anarian couldn't do anything with this hanging around, and it's been around for.
Is Anarian the only party in the case right now, or are the other parties still in the case?
The other parties are in the case by virtue of of this appeal.
What are they pursuing?
The other
settled the case. What is it that they're pursuing if the case was settled? You're saying you settled the case. What are they pursuing?
Yes.
What's the prosecution for? Who are they pursuing?
Well, the case was settled, Your Honor. The case was settled back in 2013. They pursued the case for 7 years.
Did you have a written settlement agreement? Do you have a settlement agreement?
Yes, we do, Your Honor. There are letters going back and forth which formed a settlement agreement. It wasn't your normal. I think it was for $6,000 or $7,000 for the past HOA dues, which were paid. But yes, there is a written settlement agreement. Is it in a traditional settlement agreement where it's all in one? No. It was found by Judge Williams to be. It's combination of emails going back and forth, offers, acceptance, and performance moving forward.
So what were they pursuing? What are they pursuing?
What is the HOA pursuing?
Yes. Yes.
The HOA was pursuing a judgment against parties, because Anarian was still involved in the case. It was a necessary party in a case that had already settled. That's why it's so confusing that Mr. Leipzig is appealing this case, Your Honor, because if Anarian is successful on appeal, the judgment stands. If Anarian is not successful on appeal, he still has a settlement agreement, but what Anarian is looking for as a party to the case is a final judgment, which means remove the stay on enforcement because of the appeal, and also remove the res judicata effect, or the lack of a res judicata effect on the because we don't have a decision on the merits yet.
Well, let me ask you this. Judge McClarty asked you the effect of this March 18, 2020 order. I thought it's my understanding that order indicates that the HOA in Leipzig have settled.
That's correct. That's what it indicates. I haven't seen the settlement agreement. Anarian never even received notice of the settlement of the case. The court might note that in July, I believe, of this year, there was a letter sent by a paralegal from the former attorney.
If they've settled and you've settled, why isn't this case moot?
Your Honor, they have settled, but Anarian is not finished yet. Anarian has not been able to enforce the judgment, the settlement agreement on the HOA. Here's Your Honor. This is. I understand.
You have your time on rebuttal.
Yeah. Okay.
Okay. Thank you.
As far as the appellees on the case, do we have two arguments or one?
Your Honors, we were both going to present oral argument. Would you rather hear from the HOA or appellee Leipzig first?
You can do it any way you want to. You have a limited amount of time for your side, and you can divide it up any way you want to.
Thank you, Your Honor. I'll proceed first on behalf of appellee Leipzig. Good afternoon. Patrick Newsom on behalf of appellee Leipzig. Kirk Leipzig.
You're going to exactly have 7 minutes and 30 seconds. Is that right? And
yes, Your Honor.
Okay, go right ahead then.
I guess first to your question, Judge McClarty, did the attorney for Anarian Investments represent anybody else in the case? The answer to that question is yes. Very early on, he represented my client, or at least filed a notice of appearance very early on. It's Technical Record Volume 1, page 23, and then later withdrew. I just wanted to clear that up. I would respectfully contend that what the appellant is asking the court to do is solve a Rubik's Cube with 7 sides, which simply can't be done. No matter how many ways or times that you spin it, the facts and the law do not line up to allow this court to grant the relief that Anarian is requesting. The most glaring issue, as I believe the court noted in its previous orders, is jurisdiction. Anarian in its brief argues strongly that it was a party, has always been a party to this case because it has to for standing purposes. The problem with that argument is that if Anarian was a party to the circuit court trial case, then the March 18th, 2020 order resolving the matters between the HOA and appellee Leipzig was not a final order, and this court does not have jurisdiction under Tennessee Rules of Appellate Procedure 3. We would contend that Anarian, the appellant in this case, was never a party to this case and has no standing. If the court a cursory review of the record indicates that the only claims ever filed were filed by the HOA against appellee Leipzig, my client. The HOA never filed any claims against Anarian, the appellant here. Mr. Leipzig, my client, never filed any claims against the HOA. Mr. Leipzig didn't file any claims against Anarian, and likewise, Anarian has no claims against the HOA. if you look on page 16 of the appellant's brief, you will find that it is arguing that they've always been pursuing the following claims against the HOA. Number one, breach of the Anarian settlement agreement. Number two, request for damages and specific performance and or rescission of the settlement agreement. Libel of title is number three, and then expungement and removal of real property liens against the property. The problem is there is no citation anywhere in the brief to the record because those claims simply do not exist. There is no pleading in the case filed by Anarian, whether it was general sessions or circuit court, asserting claims against anyone. Therefore, Anarian was not a party to this case. There's the record is 6 volumes. It is very voluminous, and there is not one pleading where Anarian is asserting claims against anybody. To further show how hollow Anarian's standing claim is, the very order in General Sessions Court that Anarian is asking this court to enforce was entered on February 10th, 2014, transcript volume 1, page 22. That order, which Anarian is arguing that it wants this court to reinstate somehow, does not reference anything about breach of the Anarian settlement agreement or the other claims it is listing that it has always had against the HOA.
Is Anarian even referenced in that judgment?
It is. It was the order, the February 10th, 2014 order in General Sessions Court was prepared presumably by Mr. Johannesson. It was an attorney prepared order, but it does reference Anarian in the order.
Well, if there's an appeal to the circuit court, don't all the parties in the General Sessions Court go to the circuit court on appeal?
Well, the notice of appeal that was filed, it appears that it was, but the only claims were between the HOA and Leipzig. What is very confusing about this case, Your Honor, is that nobody asserted any claims against Anarian, and Anarian asserted no claims against anybody else. And so in circuit court, under Rule of Civil Procedure 24, in order to intervene in a case, one must file a motion to intervene accompanied by a pleading, and that's for a reason, to show what claims that party has, what is the basis of their intervention. That was not done either at the General Sessions Court level or the circuit court level.
So the General Sessions Court rules require a written pleading to intervene in the General Sessions Court?
I don't believe the General Sessions rules even address that, Your Honor, to my knowledge.
What did you just say then? Maybe I missed what you just said. What did you say about the General Sessions Court?
My point was that neither in General Sessions Court or circuit court was there ever a complaint and intervention filed on behalf of Anarian.
But I mean, can that be done orally in the General Sessions Court?
Your Honor, I don't believe there's a procedure to do that, but there's nothing in the record. There's nothing in the record stating any claims that Anarian has against any other party in this case.
Okay. All right.
You know, again, even in the case cited in my brief, in Re Nevea, I guess it was held that even when a person files a motion to intervene and it was never ruled upon, that person never becomes a party to the case. As for Anarian's alleged interest in the property, those claims are absolutely moot by virtue of the resolution of the case between the appellees, the HOA and Mr. Leipzig, by the March 18th, 2020 order. And I would contend, Your Honor, that that order should stand. There is no reason to overturn that order. Again, we go back is if this court finds that Anarian was a party, to the circuit court, it does not have jurisdiction because the March 18th, 2020 order was not a final order. And with that, unless Your Honors have any questions, I believe
Did
that
the Homeowners Association file a lien against the property?
I'm sorry, Your Honor.
Did the Homeowners Association file a lien against the property for failure to pay the assessments?
I'm not sure if that's in the record, Your Honor. I do not know the answer to that question.
Okay.
Thank you very much.
Can I ask one more question? In that order of March 18th, was it granted? Was there Rule 5402 language in that order?
Your Honor, I cannot remember off the top of my head.
That would make a difference, wouldn't it?
No further questions? And we will proceed with the next argument. Yes, sir.
Good afternoon, Your Honors. Neil McIntyre, if it pleases the court. I'm counsel for Hampton Reserve Homeowners Association. I can answer a few of the questions that have been asked, specifically, Judge Golden. Yes, the association filed notices of liens against the property as further proof and effort of their collection for unpaid homeowners fees, the assessments that had not been paid, as well as for attorney's fees. Part of the problem, I believe, and we're getting a little bit far afield from the procedural aspect, but I'll come back to that. But I do want to give Your Honors the lay of the land there, because there were liens that were placed, or there were notices of liens that were filed to secure attorney's fees that were still at issue, never resolved, never agreed to in the context of whatever workout was attempted by Anarian or Mr. Johannesson and the association. So that was the nature of those liens. Interestingly enough, Your Honor, when the property was transferred in 2014 or 2015, those liens were extinguished. So by virtue of the transfer of the property, those liens became moot or mooted and went away. There are no more liens on the property. So if one of the components of the request for relief is to withdraw the notices of liens, the record is clean. There is no more cloud on the title on this property by virtue of any lien that's placed on the property by the association related to those particular homeowners fees that were at issue when this original collection action was filed. I hope that.
And who was the property transferred to, Mr. McIntyre?
That is a great question, Your Honor. I do not have that particular record. It did not involve the parties. It did not involve the association. It was Anarian, or excuse me, it was Mr. Leipzig, the current owner of the property at that time in 2013 or 2014, that sold the property. I don't have that in front of me.
Did he sell it to Anarian?
I don't believe so. I believe that there was a third party. The name Dr. Jacobson comes up, but I don't know if this was a transfer directly to Dr. Jacobson or if it was a corporation that Dr. Jacobson set up. I don't have that information.
But in any event, the liens have been extinguished. Is that right?
That is my understanding. Yes, Your Honor.
Okay.
So association wants to make 3 points, some of which you've heard, but I think they bear reiterating. Subject matter jurisdiction is the threshold issue here. We heard Mr. Johannesson argue that Anarian never received a copy of the agreement, the settlement agreement that was entered into between the association and Mr. Leipzig. He was unaware that agreement had in fact been entered into. That begs the question, how then can this court interpret the notice of appeal that was filed after the January 22 order, setting aside the January 2, 2019 order of dismissal? I don't believe it would be logical for the court to conclude that March order, the March order that resolved the dispute between the parties, between between the association and Mr. Leipzig, could constitute a final order for purposes of appeal. That's the subject matter jurisdiction question that the court has to wrestle with. Point number 2. And
was there 5402 language in that March 18, 2020 order?
Your Honor, there was not. And the reason for that is this. On January 22, 2013, when the court entered the order setting aside the January 2nd, 2019 order of dismissal, the court specifically found that Anarian was not a party to the lawsuit. That language was included in that order that was signed by Judge Martin. So at that point in time, in March of 2020, when the final order was submitted that reconciled the differences between the association and Leipzig, Anarian, by order of the court, was not a party to the lawsuit. there would have been, there would have been no reason to include 5402 motion or language in that order.
All right.
Mr. McIntyre, let's clear this up. Who filed the appeal of the General Sessions judgment?
That would have been Hampton Reserve filing the notice of appeal from the General Sessions judgment.
And you did that because you were dissatisfied with the ruling about what was owed, or what?
That's correct. I mean, I did not represent the association at that point, but from my understanding and reading of the record, the association contended and was in the process of contending in that General Sessions matter that the association's remedy as the result of its collection action against Mr. Leipzig or against the record owner of the property was not just the unpaid assessments. It was also the attorney's fees. So At that point in time, what was still left to be discussed and decided was the attorney's fee award, which had not been paid and which was still at issue. Therefore, when the case was dismissed by the General Sessions judge, that issue was very much still alive, which was the reason that the association pursued the appeal.
And once the appeal was filed in circuit, then you worked out a settlement of the entire case, including what was owed in assessment fees and the attorney fees.
That is correct. That is the nature of the March 22 or the March 20 order, the March 2020 order between Mr. Leipzig and the association. They worked out their differences, whatever unpaid assessments, whatever unpaid attorney's fees were at that point determined and agreed upon to be owed were satisfied by Mr. Leipzig. The association was comfortable with what they received, thus the order dismissing their dispute.
Okay.
The question that remains in my mind is, it's one that the court actually asked in its July 16, 2020 order that was entered. That found that the March 18, 2020 order constituted a final judgment that was appealable as of right, but the court specifically said that it was concerned that it did not know what Anarian sought. And I still don't think we've heard clearly today what Anarian is seeking. The parties in dispute in the General Sessions action have resolved their differences. The last piece of the puzzle was the payment of whatever unpaid balance or amount by Mr. Leipzig. And when that was accomplished, the parties to the General Sessions lawsuit have resolved their differences and they entered a proper order that was a final decision in the case, and it dismissed the case. There simply is nothing further to be done.
Thank you, sir. Mr. Johansson, I think you have your rebuttal.
Thank you, Your Honors. Well, as to the issue of the three liens, there were three liens recorded against the property after the, and I believe it was in September or October of 2013. They're still on the property. They're a cloud on the property. As to the settlement agreement.
Why does that matter to you, Mr. Johansson, since you don't own the property?
Because, Your Honor, there is still a option to purchase the property, and those liens on the property are getting in the way of financing. A lot of this stuff, Your Honor, that is mentioned by counsel for the HOA is not even in the record. The settlement agreement about Mr. Leipzig paying everything, I don't even know if that's true. Haven't seen it. It's not in the record, so it's a bit odd to argue it in the abstract. But what I do know is Mr. Leipzig was refusing to pay anything because the case had settled, and that's why one of the reasons why. And also, they sued the wrong party. That's one of the reasons why Mr. Leipzig didn't show up for the.
Well, that's not a claim you can bring. They didn't sue you as a wrong party. I mean, that's for Mr. Leipzig to raise as an issue. It's not for you to raise, is it?
No, Your Honor. But for this, the General Sessions Court Judge Williams knew that because of the briefing and the evidence before him that Mr. Leipzig was not the right party. So that's why when the judgment was entered for three people, to benefit three people: Anarian, the HOA, and Mr. Leipzig. The HOA happened to have been on the wrong side of the judgment. The HOA's attorney, contrary to what Mr. Leipzig's attorney mentioned earlier, The HOA's attorney appealed the judgment. It didn't appeal a claim. It didn't appeal anything other than the judgment. And that judgment had 3 parties. And the reason, one of the primary reasons why the judgment was entered in the General Sessions Court is because Anarian had an enforceable contract, which the court found, and that was an offense to the entire action. You cannot sue somebody when you settled the case. This idea of the, attorney's fees and that type of thing, that's an issue that it's off the record. I know there's something going on between the HOA and the prior counsel. But that's not in this appeal. The fact of the matter is 3 parties went up on appeal to the circuit court, and the case was settled without Anarian's participation, and Anarian has been holding on to a non-enforceable judgment for 7, almost 8 years now by the General Sessions Court because of this delay. It was a purposed delay. There were 3 or 4 different dismissals. It was a purposed delay because once the case becomes final in circuit court, then the judgment against the HOA's, Anarian's judgment becomes final. It's res judicata effect. That's one of the things they've been trying to delay.
Okay.
Your Honor, I could. I'm looking at what other issues they brought up about. There was a statement that Anarian is not a party to the lawsuit. Well, it is. It's clear it is, and everybody's agreed until now that it was. Even the circuit court agreed that Anarian was a proper party until the January 2019 order, which unfortunately I was unavailable. I couldn't get back for a hearing that was scheduled over Christmas. But that terminated it as to Anarian, which made that order appealable as well. Anarian, all Anarian right now is looking for, Anarian is not attempting to turn around a settlement that Mr. Leipzig had at all. That's why it was surprising that Mr. Leipzig is even involved in this appeal. What Anarian wants to do is have finality to the judgment. Otherwise, with this settlement, there's no finality.
Okay.
Absolutely no finality and no day in court. I mean, it's truly a justice delayed is justice denied.
Okay. Your cases have been submitted. We will review this case thoroughly, and you will receive our opinion in a due course of time. The attorneys may be dismissed. Thank you very much for your argument.
Thank you, Your Honor.
Thank you, Your Honors. Thank you.
Honorable Court is now in recess until 3 p.m.